She liked to cook, and I remember sitting on her lap and watching cooking shows with her. She liked to help people as much as she could.
Me and my sisters were close to my mom. We told her everything. I miss her so much.
My mother had an amazing heart. I miss her so much. She died a day before my birthday. You never deserved anything like that.
Nobody deserves anything like that. Alone, slowly bleeding to death in a dingy Edmonton hotel bathtub, while the man who did this to you sleeps on the other side of a thin wall. Her 3 daughters, who wrote those touching words, know the terrible details. Old enough to remember, too young to be motherless. It was June 20th, 2011, and Cindy Gladue's boyfriend at the time was here at Lucky's Lounge, where he met a long-haul truck driver named Bradley Barton. Barton had said that he wanted to be with a woman. So the boyfriend went home, got Cindy, brought her back here, introduced the two. She emerged a short time later with $60 and came back to meet him again the next day. Cindy's struggles with alcohol and crack cocaine compelled her to sell her body. She was to make another $60 off Barton. They met in the lounge. That's them there at the top of the screen. The server brings them drinks. They had many more before leaving. Here they are heading to his hotel room. Barton asked a co-worker, this man, if he wanted in on the action. The man declined. So Barton and Cindy went to his room. Walking in here at 12:42 a.m. on June 21st, 2011 was the last time she was seen alive.
Edmonton 911 emergency for police, fire, or ambulance?
Police, please.
And what's the emergency?
It's a long story. I woke up. There's a girl in my bathroom friggin' covered in blood.
Okay, so she needs an ambulance then, sir?
I don't know. I've never touched her. She came in. I was in a hotel, and we're all partying that, and she came back and had a shower, and I fell asleep on my bed, and I woke up this morning, she's laying in the tub with blood all over the place.
Barton was patched over to police dispatch.
Do you know if she's breathing or anything?
I didn't even want to touch her. I just poked her in her stomach a couple times today. Wake up! What are you doing?
Yeah.
What's going on?
And she's covered in blood?
Yeah, like the tub's covered in blood and everything.
Oh, okay.
An autopsy showed the Cree mother, daughter, and friend died of a horrific injury, revealing an 11-centimeter slice inside her vagina. She slowly bled to death. During one of the police interviews in the days to follow, Barton was told the surveillance footage shows he lied to 911. Barton eventually admitted he did know the woman who died in his bathtub, but he insisted he didn't know what killed her. It was an act of God, he said. Barton was charged with first-degree murder. Tony Blake covered the 2015 trial for the Edmonton Sun.
If someone kills someone while committing a sexual assault, which was what the Crown's allegation, it's first-degree murder.
The Crown asserted that Barton intended to kill her by inserting a sharp object inside her vagina, or the burly 6'4" trucker intended to harm her using extreme penetrating force, possibly just with his hand, seen here in a police outline. Edmonton police had found a bloody towel that Barton disposed of outside the hotel, but not a murder weapon. The defense said that's because there wasn't one. The two had consensual rough sex and she accidentally died, so there was no murder. Naomi Sayers is a Toronto sex worker advocate, law student, and popular Indigenous blogger who followed the trial.
When I hear the name Cindy Gladue, I have this frustration growing inside my stomach every time I talk about her. Not talk about her, but I talk about the case. Because of how the courts treated the case. Not only the case, but her body.
Courts have also determined that someone with a blood alcohol content as high as Cindy's cannot legally form consent. Her blood alcohol was 340, more than 4 times the legal driving limit, and in the range of what can be fatal alcohol poisoning. Barton's defense, nonetheless, was that Cindy, cripplingly drunk and bleeding profusely, somehow managed to get out of bed, and walked to the bathroom while Barton fell asleep until the next day. The Crown said it was more likely Barton carried the bleeding woman from his bed to the tub and let her die.
But they had no proof of that, and also no murder weapon. Perhaps it was desperation that led them to make a shocking decision.
As I reported at the time, it was believed to be the first time that such an exhibit was used in a murder case in Canada. The Crown's expert was arguing that force was used and there was a tear inside the vagina, so he wanted to be able to demonstrate that. And the defense had their own expert, and she was, obviously had a different opinion, but she used the exhibit as well.
Muriel Venn is president of Edmonton's Institute for the Advancement of Aboriginal Women, a group that advocated for Cindy and her family throughout the trial.
Of all the things that happened, that was done by the Crown, which is even worse because they calculated it. If she hadn't been Aboriginal, they would never have done that. They've never dared to do that.
I don't know how that decision was made, but it was a wrong decision. Something went wrong in a room somewhere, and nobody said, we need to not do this, and we need to think of a better way.
But her most intimate body part being paraded through a courtroom was not the final indignity.
An Ontario trucker has been set free by a jury in Edmonton after being found not guilty of first-degree murder in the death of an Indigenous woman working in the sex trade.
Horrific in the sense of what the Crown prosecutors did and the jury did in acquitting this man who had killed her.
Reaction was swift.
Protests are being held across the country today. About 1,000 people took to the streets of Edmonton.
Cindy Gladue's name should not be ever forgotten.
Well, we called it our breaking point because this just spread like wildfire.
This protest in Iqaluit was like the protests happening all over the country.
The way she was treated and the verdict of the case is a symptom of systemic racism that needs to be addressed in our country.
In Winnipeg, a winter storm rolled in as the crowd formed. Some felt the weather was an indication of what they say is the cold-heartedness of the judicial system and the way Canada is treating Indigenous women.
You know, with its verdict of an acquittal, sent a message to Indigenous women and to sex workers that their lives are not valued. You know, it's basically sending a message of impunity, that it is okay to kill an Indigenous woman or to kill a sex worker and walk away free.
The outrage was what people like Venn had been waiting for.
We're amazed and surprised and so happy about that because finally the word was getting out that we've been trying to articulate all these years.
After the protest, people began scrutinizing the trial. How could this have happened? Police had found Barton's laptop contained violent pornographic images. The judge in the case had deemed it inadmissible, so the jury never got to know that. And there was other things the jury didn't hear as well.
I felt, based on what I heard, and I have to add that I heard some things that the jury didn't hear to do with his conduct, that'd be Bradley Barton, sort of after the killing. And I felt that maybe, I wasn't sure that I believed his story, put it that way.
Then there was the way Cindy was repeatedly referred to in court.
There were a lot of references to the victim being Native and a sex trade worker, and we don't know, but I mean that could have swayed the jury, some of the jurors in any direction based on the fact that she was there and doing what she was doing. It could have negated consent, even though that's legally wrong.
And the judge's instructions to the jury.
Jury charges are difficult at the best of times, and when a homicide's involved and the judge is trying to explain, you can come in with a not guilty verdict, you can have first-degree conviction, or conviction of first-degree murder, manslaughter. It's very, very complicated, and myself, I would be just like one of the members of the jury. Maybe I had a little more experience in the courtroom, but even lawyers, I would suggest, would be confused by these charges. They take hours and they're hundreds of pages long.
All of this was enough for the Crown attorney to go to the Court of Appeal seeking a new trial. A panel of judges took nearly a year to consider the matter, Their 80-plus page scathing decision cited numerous problems with the trial and called for a reset on how courts deal with sexual assaults. They said that Bradley Barton would be retried on first-degree murder. When we come back, what the appeal court's decision means for future victims of sex crimes.
That's the way precedents are set.
Before the break, we heard about Cindy Gladue, a woman who died having sex with a man who was to pay her $60. An appeal court took issue with many of the things at the trial that led to Bradley Barton's acquittal and deemed that he would be retried on first-degree murder. This case has exposed the flaws in the legal infrastructure used for instructing juries on sexual offences in Canada, reads the Court of Appeal ruling. They went on to say, "We have determined that errors of law in the trial and in the jury charge were several in number, serious in scope, and significant in impact. The time has come to push the reset button for jury charges in this country for cases involving an alleged sexual assault." Muriel Venn is president of Edmonton's Institute for the Advancement of Aboriginal Women.
The language was very clear and very courageous and very making us very, very happy about this.
Jennifer Koshin is a University of Calgary law professor.
I think Barton is a very important decision. It gave the Alberta Court of Appeal an opportunity to talk about some of the problems that have existed over time in jury trials in the sexual assault context, and also to reinforce how important it is for judges and lawyers who are involved in those sorts of cases to ensure they aren't speaking in a way or introducing arguments that may reinforce stereotypes about Indigenous women and about sex workers who are victims of sexual assault.
To us, it is absolutely marvelous piece of work that hit on the really desperate situation in which Indigenous women find themselves in this country.
There's no shortage of examples to pull from. Here's what a 19-year-old Cree woman, a sex assault victim, faced in court.
Pressure on federal court justice Robin Campbell all day for comments he made as a lower court judge during a sexual assault trial.
That young women want to have sex, particularly if they're drunk. Sex and pain sometimes go together, he said. That's not necessarily a bad thing. And asked why the complainant didn't keep her knees together.
That same year, a 28-year-old Cree woman faced this.
Angela was a victim of sexual assault and attempted murder, but was treated like a criminal. In 2014, Lance Blanchard, a known sexual predator, he raped a 13-year-old girl in 1975, assaulted Cardinal. She managed to call 911 while being attacked. Blanchard's trial began a year later. As a witness against Blanchard, she fell asleep in the courtroom and had problems answering questions. Prosecutor Patricia Ines recommended she spend the weekend in the remand center. Judge Raymond Bodnarek agreed. She ended up staying there for 5 days. She was placed in shackles and forced twice to ride in the escort van with Blanchard, the man who nearly killed her.
An outraged public called for an investigation into the failings of the system when it comes to Indigenous sex crime victims. But Cardinal, whose real name is protected by a publication ban, was killed in an accidental shooting before it got underway. Here's Alberta Justice Minister Kathleen Gainey.
And to the young woman who tragically cannot be here to hear these words, I'm sorry. We can and we must do better. Those are the words I delivered to her mother when I met with her last week, and those are the words I will continue to deliver as we work to bring much-needed improvements to our justice system.
These cases and Cindy Gladue's all tie into the bigger picture of missing and murdered Indigenous women and girls. Normalized and widespread violence. Statistics Canada says Aboriginal women are 3 times more likely to experience violence than non-Aboriginal women, making them the most brutalized segment of the Canadian population. And the statistic is true regardless of whether it's a stranger, a partner, a family member, or an acquaintance who's committing the violence. Emma LaRocque has spent much of her career studying why and how it connects to sexual violence. She is a Métis poet, historian, and author who teaches Native Studies at the University of Manitoba. She's been waving red flags about systemic violence against Indigenous women for decades.
In 1991, I sent a letter, I guess, to Aboriginal Justice Inquiry on issues of violence against women. So the quote that I'm reading was part of that. The portrayal of the squaw is one of the most degraded, most despised, and most dehumanized anywhere in the world. The squaw is the female counterpart to the Indian male savage, and as such, she has no human face. She is lustful, immoral, unfeeling, and dirty. Such grotesque dehumanization has rendered all Native women and girls vulnerable to gross physical, psychological, and sexual violence. I believe that there is a direct relationship between these horrible racist, sexist stereotypes and violence against women and girls.
This imagery, this stereotype, goes back to Contact. Here she reads from a 1505 journal entry by Italian explorer Amerigo Vespucci.
The women, as I have said, go about naked and are very libidinous. When they had the opportunity of copulating with Christians, urged by excessive lust, they defiled and prostituted themselves. This is as far back as it goes. And I've read these same things in many other, like, fur trade journals. And often, men who write these things, they didn't have any encounters with Indigenous women. How would they know in the first place? They didn't speak Indigenous languages. And especially Vespucci, he actually may have not seen anything. This was sensational literature written to sell. It was pornographic literature of the times. Every generation of European men who came to the Americas, they did the same thing. I think they plagiarized this guy. And so the history of that, the portrayal of Indigenous women as being mere repositories of male desires. It's also global. It's very colonial.
Aboriginal women live in a country that is hostile to their very existence. And that is shown in every statistic, every kind of incident that happens to hurt Aboriginal women. It's just this awful situation which is directly related to colonialism. I mean, the Indian Act is the personification of all those ills.
It's why she started the advocacy agency decades ago.
There's a long way to go, but I feel that women are being recognized as human beings, and Canada has yet to recognize the Aboriginal women as human beings.
Her agency put together this literature. It's an homage to Indigenous women, to the missing and murdered, to the survivors, to the ones victimized by society and the court system that's set up to protect them. It was inspired by Cindy. The letters written by her daughters, which we heard at the beginning of the show, were published here.
This is part of the reconciliation movement that's taking place in this country, and this is such a vitally important reconciliation that could have long-lasting and permanent changes to our way we think about Indigenous women and the way we think about Indigenous people.
For her part, Koshin was instrumental in leading the charge against the judge who made the "keep your knees together" comment to the sexual assault victim. He resigned when it was apparent he was going to be removed from the bench. The Alberta Appeal Court quoted some of her advocacy work in their reasons for ordering a retrial for Barton.
I was doing some work in England at the time, and I was looking at their model instructions for juries. And what I found quite interesting by way of comparison is that those instructions went into a lot of detail about how sexual assault judges or judges in sexual assault cases should be very explicit in warning juries about the need not to engage in stereotypical reasoning or to perpetuate myths about women in sexual assault cases, or about victims more generally. And when I looked at the jury instructions in Canadian trials, they were much less explicit about that. Cindy Gladue, the victim in the case, was referred to right from the outset of the trial by the lawyers as having been engaged in the sex trade. And that was done without going through the usual application under the criminal code to introduce sexual history evidence.
She calls for better training for judges.
Judges do get some training when they're first appointed to the bench, and it does include some training on sexual assault law, but I think given many of the cases that have been before the courts recently that have exposed how that training may not be sufficient, I think there's definitely room for more to happen in that regard. So I think we've done a pretty good job, for the most part, at creating a good, strong set of laws. The problem comes more in the application of those laws, and I think that circles back to the need for more training for judges and other players in the justice system in these cases to ensure that those laws are being applied appropriately.
If they're treated differently in the court, will that fix the problem?
No, it'll help. Anything that the so-called justice system can do to make changes, of course that will help. But no one system can fix this problem because it's multi-pronged. It's very historic in nature.
Barton's retrial is set to begin in February 2019. Cindy's family agreed to be interviewed for this piece, but had a change of heart after the appeal court called for a retrial. A family member told APTN they didn't want to relive the first trial before having to go through a second. Interview requests made through Barton's lawyer, Dino Bados, went unanswered, but a statement on the law firm's website said, "I think the Court of Appeal is making a political statement as much as a legal one. It's trying to correct every perceived inequity in sexual assault law in Canada in this judgment, and it went far beyond what the Crown on appeal was arguing, and that's not fair to Mr. Barton." This law student and activist questions the fairness differently.
When it does go back to trial, that it's going to be very hard to respect the process, but if the Crown attorney is not doing their job, the same outcome is going to happen. And the fact that they still have the preserved pelvis somewhere as evidence just proves that an injustice is going to happen again.
Late last month, Bados filed an application for leave to appeal to the Supreme Court of Canada. In a news release, he said the appeal court made several mistakes, and given the media attention, the matter deserves to go to a higher court. Whether that happens or the second trial goes ahead, this advocate refuses to give up hope.
This is the most important case ever within my lifetime. It will be the only case that I can see of such great importance as this one in my lifetime, because it's been a long time coming. The justice that we seek for Cindy Gladue is, I hope, on its way.